and good afternoon, everyone, and welcome to today's panel discussion entitled Eviction Prevention, Understanding Tenant Rights and Resources. If you'd like to use the CART services for closed captioning, please click on CC and then show subtitles to turn the captions on. Also, we want to let you know that although this presentation is being recorded, only the panelists will be recorded and participants will not be identified. My name is Maura Pensack, and I'm the housing liaison to the city manager here in Cambridge. We have with us today three extremely knowledgeable and experienced experts on this very important topic of eviction prevention, rights, and resources. We're joined by Miriam Georges, housing and disability attorney at the De Novo Center for Justice and Healing. Also by Susan Hagel, housing attorney from the Cambridge Somerville Legal Service Office of Greater Boston Legal Services, and Maria Mello, the director of the Cambridge MultiService Center in the Department of Human Services here in Cambridge. Today's panel is part of our newly launched Housed in Cambridge Information to Open Doors campaign. So before we get started, I just wanted to say a few words about the campaign, and then we will briefly explain how the webinar will work, and then we'll hear from our team of experts. Housed in Cambridge is a year-long multi-department outreach, education, and information campaign that's designed to promote and inform residents about all things housing and all housing-related resources and services. The City Manager's Office, the Community Development Department, Human Rights Commission, and the Department of Human Service Programs and multi-service staff have been working together on this comprehensive platform because we're committed to improving the housing experience of our residents. And we know that to improve access and opportunity and to prevent eviction, it's essential that we educate the public about rights and the many housing services and resources that are here in the city. We also know that processes can be confusing and overwhelming. So we hope this campaign serves to connect residents to the people and places that are available to assist with understanding, navigating, and accessing resources and services and systems. We also want to acknowledge that this campaign would not be possible without the support of the many provider partners in the city who offer affordable housing opportunities and housing-related resources and services, such as our legal service partners who are with us today. Although we officially launched this campaign last week, back in April, we started with a soft launch in celebration of Fair Housing Month, during which we hosted 3 panel discussions by other local partners and providers and city departments. The prior panels were affordable housing, understanding options, opportunities, and pathways. Also fair housing and basic tenant rights. And the third was home ownership in Cambridge, resources for first-time home buyers and existing owners. If you missed any of these and would like to watch them, they are also recorded. And at your request, we can send the links. And soon they'll be available on the city's website as part of our housing video library that we are creating for this campaign. But this panel series is only one component of the Housed in Cambridge campaign. Through this campaign, we now have a new interactive online guide to help residents learn about Cambridge housing providers and navigate resources they offer. The interactive guide is organized around 6 themes: affordable housing, emergency housing, housing rights, legal and mediation services, safe and healthy homes, and financial assistance. The online guide can be accessed at cambridgema.housing guide. And for this, I just have to give a quick shout out to the fabulous team of Emily Solomon from Community Development and Crystal Rosa from the Human Rights Commission, who for many years organized the city's annual Affordable Housing Resource Day. In addition to that event being the genesis of this campaign, they turned the pamphlet that was used for that event into an interactive housing resource tool. In addition to the tool, through the campaign, we also plan to develop other informational materials, and we'll continue these monthly webinars in order to continue to build an online housing information library. And now that we're all able to start gathering in person again, we'll begin in the fall to have in-person trainings and roundtables. So please share this information with your family, your friends, and neighbors, and stay connected through the city's website and the city's social media platforms. Watch for upcoming panels and let us know what you think would be helpful to hear about and to discuss. And now I'll turn it over to Crystal, the genius behind the screen, to explain a little bit about the logistics of the webinar and how to use the question and answer feature to submit questions. Crystal?
Wonderful, thank you. Just bear with me as I share with sound. Perfect. And present. Here we go. So as Maura explained, you can drop your question on the box that says Q&A. Only presenters will be able to view your questions. The presenters will verbally respond to many questions as possible throughout the presentation. Your typed questions will not be recorded, and you can send a question anonymously. And you will also be provided after the end of this webinar more resources to come. So I'm going to stop there. There you go. Thank you.
Thank you, Crystal. So we'll get started. Eviction prevention, understanding tenant rights and resources. Since you've joined this webinar, I don't have to tell you how important this topic is. Housing instability, being concerned about losing your home for whatever the reason, being behind on rent, and or being given a notice to quit is the most stressful and in fact traumatic situation that anyone has to experience. While this has been true before the pandemic, it is even more true now. So our hope today is to share information that will assist you and your family or neighbor in not only knowing about tenant rights, but also where to find resources and services that can support you during such a difficult time and keep you in your home. Our speakers today will cover important questions such as what does it mean that the eviction moratorium has ended? What do I do if I receive a notice to quit? Do I have to leave? And is there assistance if I fall behind on my rent? In addition, as Crystal described, we invite you to submit questions through the Zoom chat and question and answer feature. However, if you have questions of a personal nature, this might not be the best venue to ask them. But again, as Crystal said, the panelist contact information will be provided at the end of the presentation if you want to follow up on a one-on-one basis. And so with that, we'll begin with Attorney Miriam Georges from De Novo Center for Justice and Healing. And she'll talk about the eviction moratoria that have been in place and what it means that it's ended and what it doesn't mean. Miriam?
Thank you, Maura. Hello, everyone. So I will be talking about the eviction moratorium. Right now, we have an eviction, the CDC moratorium that is set to expire at the end of the month. However, unless it is extended. However, it's important for you to know what does it cover. Right now, the CDC moratorium it does protect tenants who are facing non-payment evictions and have signed what we call a CDC declaration form, explaining that they have used their best efforts to find rental assistance. They will not be making a certain level of money during the year, and they have used their best effort to make full or partial payments because they do face a substantial loss of income at this time. And also that an eviction at this time will render them homeless. However, it's important for you to know that the CDC moratorium does not protect every tenant. It does protect tenants who are facing a non-payment eviction and have signed the declaration form. All adults on the list must sign the form. It's important for you to know that the CDC moratorium, what does it do once you file it, once you give it to your landlord? In district court, the eviction is paused. However, in housing court, what happened is it goes through the normal process, but there won't be any levy, which means that if a court finds against you, what happened is they will not order you to leave your unit at the time. It can happen afterwards, but you do have some time. But there are other level of protections at this time during the pandemic. One of them is Chapter 257. Chapter 257 is a state rule. What does it do? it protects tenants. It does require some information once your landlord provide you with a notice to quit. And also, if you do make some efforts and you are in the process of finding some rental assistance, it does require the other side. It does require for you to obtain what we call continuance, some time for you to go through the process, and so you can go back to court and continue with the process. It does give you a bit more time. What does the notice to quit? What should the notice to quit contain? What should come with it? So first of all, it should come with some information explaining whether you receive the CDC, whether you provided actually the CDC declaration form to the landlord. Also, some documentation about whether there is an agreement between you and the landlord regarding the non-payment. And also, it should provide you with some information about the rental assistance program, such as the Residential Assistance for Family in Transition, which we call RAFT, and also some other rules. And but very important, at the bottom of the document, there should be some language that says exactly this notice to quit is not an eviction. You do not need to immediately leave your unit. You are entitled to a legal proceeding in which you can defend yourself against the eviction. Only a court order can ask you to leave your unit. It's very important for you to remember that part. Once you receive the notice to quit, you do not have to leave your unit. You must leave your unit once you receive a court order, but not until you go through the entire process. You do not have to leave your unit once you receive a notice to quit. There are also other rules that you need to know, or that we should provide you some information about. The cities, Cambridge, Somerville, do provide some protection for tenants. And it's very important for you to know that, for instance, Cambridge has what we call a tenant basic housing rights, basic housing rights and resources that your landlord must provide you with. Once once the landlord give you the notice to quit, the landlord must also provide you some important information. The basic housing rights and resources about some organizations in your area that can assist you with the eviction process. And also, such information must be provided at least 30 days before they actually file a case against you in court. Both Cambridge and Somerville do require your landlord to provide you with such information. And I will also really really know that it's important for you, if you receive an eviction notice, if you do not just go to court, but try to get some assistance from one of the legal organizations, or get some legal assistance, because the process is really fast. It's a fast process. Please do contact one organization to get some assistance and ask some questions about the process.
All this time, and I'm really still to get to unmute myself. Thank you, Miriam. That was terrific. And so what I heard you talk about was the federal moratorium, which is still in place, the CDC moratorium that is set to end on June 30th, and that there are other protections. And thank you for pointing out the tenant notification rights and resource ordinance that Cambridge has, because a lot of people do get that confused, because since the Cambridge moratorium ended last week, because the state of emergency in the state ended, a lot of people are a little bit confused and think that the tenant notification also requirement also ended. And so thank you for pointing that out, that is still required. It's a permanent ordinance, and people do need to receive that and should expect to receive it when they receive any notice to quit or non-renewal from their landlord. So thank you. I also heard you talk a lot about the call us, and there's a process, and that's a great segue to Attorney Susan Hagel, who will pick up from there and explain what the process is. because as Attorney George has said, once you get that notice, that is not the end, that is the beginning, and there's a lot of steps. And so I will turn it over to Attorney Zabel to discuss that.
Thank you. Good afternoon, everybody. As Maura indicated, I'm going to explain a little bit about the eviction process, and what I'm going to try to explain are the different papers that you're going to get, and a little bit about the timeline so that you know what to expect and don't panic. And picking up on what Miriam Georges said, the very first step in an eviction is generally getting a notice to quit. So that's a written document from your landlord that says you have to move out after a certain number of days. And depending on the type of tenancy and depending on the reason, it could be anywhere from 7 days to 30 to a month to 60 days, but there'll be some amount of time stated in that notice by which you have to move out. Again, you do not have to move out when you get that piece of paper. But I would urge people that at that stage that they should seek out legal help by contacting De Novo or Cambridge and Somerville Legal Services, or during the school year, you can contact Harvard Legal Aid. You can also contact either Maura or the MultiService Center, and they can get you into contact with a lawyer. So again, the first step is this written notice to quit or notice of termination. Once that time period is over, the next piece of paper you get is called a summary process summons and complaint. And that's a form that the landlord buys from the court and has a constable or a sheriff give you. So the notice can come anyway. It could come by certified mail, it could be dropped off, but this court complaint has to be by a constable or by a sheriff. And it's going to either be hand delivered to you, or if you're not home, it's going to be mailed and left there. So whatever envelope it comes in, you should save. You should always save all your envelopes and all your papers, but that complaint is going to indicate sort of the next steps. It's going to indicate whether the landlord is bringing the eviction in housing court, which is located in Boston, or if it's going to bring it in Cambridge District Court, which is located right now in Medford on Route 16. If you have not sought legal help when you got the notice, you should definitely seek legal help when you've gotten that complaint. After you get the complaint, generally within a week, the landlord will file it with the court. And once it's filed with the court, it becomes, unfortunately, a public record. So it's anybody with a computer or internet access can look on the court records and see that there's an eviction filed against you. So again, if you've gotten legal help at the notice to quit stage or before it's filed in court, there may be things to do to prevent it from being filed in court. But once it's filed, that's it. It's a public record. Before COVID, that complaint would indicate your court date. It would give you the date by which you would have to show up in court in person. And it was generally about a week and a half, 2 weeks later. Now with COVID and continuing, even though the state emergency is over, there's a two-step process. And we're not sure, but it looks like that's going to continue for the near future. And it is the process right now. So after you get your court complaint, the next thing is that the court is going to mail you a notice. And that notice is really, really important. It's going to tell you the date of and time of your next court date. And that's going to be for mediation. So if your notice is coming from the housing court, it will schedule a mediation with a court mediator. So it's somebody employed by the court called a housing specialist. And they don't represent either side. They just try to help the parties come to an agreement. And right now, Eastern Housing Court is scheduling those mediations Monday through Friday at 9 o'clock and 1 o'clock. They had been doing like 9, 11, 2 or something, but now they're seem to be doing them just 9 and 1, and every day of the week, and they're always going to be done by Zoom, or you can call into the Zoom number. Housing court does things a little differently. Right now, you're going to have a mediation, which is actually with the judge, and everybody comes to court. Again, it's by Zoom. Everybody meets by Zoom on Thursdays at 9 o'clock. So instead of having your specialized appointment in housing court with the mediator in district court, everybody is there on the Zoom and you get called one by one. In housing court, you're going to have at least 2 weeks notice of your mediation date. In district court, they seem to be in Cambridge fairly caught up, and you're going to have less notice. You may only have like a week and a half notice. So again, that's another reason, as soon as you get your complaint, get legal help. If you need an interpreter, you're entitled to a free interpreter at the mediation and at all court events. So it's important that you reach out to the clerk and request that you want, whatever language you want, Spanish or whatever, and the court will supply an interpreter at the Zoom session to interpret for you. For those, I didn't check with Maria, but for those that don't have Zoom, you can still go to the MultiService Center and they will set you up with a Zoom, a private room and Zoom, and help you get it all set up. You could also physically go down to the housing court and have your Zoom, they will also set you up in a private room, but it may be easier to get to the MultiService Center if you can't make it, don't have Zoom at home. It's very important to, buried in that court notice, it will tell you that your answer to the eviction complaint is due 3 business days before your mediation. So you're going to have to count backwards, and that's the date by which the landlord and the court has to receive your written response to the eviction. And that written response is called an answer, and it's going to say why you shouldn't be evicted. Either you don't owe the money, you didn't do what the landlord said you did to break the lease. It's also any sort of defenses that you may have relating to, like, if the landlord is sort of violating the CDC moratorium or some other defect with the notice, all that should be put in your answer. In most evictions, you also have the right to sue your landlord for anything the landlord did wrong. So if the landlord mishandled the security deposit, or if there were bad conditions, or they were doing work in another apartment without permits and it disturbed you. So anything that the landlord did wrong could be raised in that answer. And it's really important, if you don't put it in the answer, most likely it's going to be very difficult to raise it later on. And the reason it's important to put it in the answer is, for instance, if the landlord says you owe them $3,000, but you have a counter suit against the landlord for $5,000, you will not lose your apartment. You get to stay and the landlord pays you the difference. So that's a very important defense in Massachusetts, but you need to put that in that court document called the answer. So again, you should be calling De Novo, Castles, or Harvard Legal Aid during the school year, reaching out to the MultiService to get you connected. And if you're not able to get any lawyer, I will put in the chat later on, there's something called, you could Google GBLS MADE, M-A-D-E, and it will pull up a program that you can, it will ask you a bunch of questions, and it will generate the papers that you need to file in court and give to your landlord. So it will ask you your name and your address, and you just type that in and it will produce the papers. So you should do that if you have no other legal help. When your answer is due, you also, that's your deadline for asking to have a jury. So in Massachusetts, you can have your eviction case heard by a judge or by a jury. And that's in Housing court, it would be a 12-person jury, at least pre-COVID. And in district court, it's a 6-person jury. And sometimes juries are more sympathetic than a judge. So you need to sort of, again, talk to your legal advisor and decide whether you want to do a jury or not. Right now, jury trials are a lot more work than a trial before a judge, but it's also probably many, many more months away. When you have drafted your answer and your countersuit and any jury demand, you have to make sure that the court and the landlord get the papers by that 3 days before your mediation. And right now in district court, you can just email them to the court. You don't, or you can mail them, or you can drop them off. But email is probably the easiest. And in housing court, anybody can what's called e-filing. So you do have to set up an account and under your name, and you can file papers, but it's free. There's no charge to that. And so you can either file it that way, or you can hand deliver it to the court. One change coming up July 1st is that if you do not show up at your mediation, you are going to automatically lose your case. So during COVID, if you didn't show up, basically nothing happened. Sometimes they would give you another date. Sometimes they would just move on. But now if you don't show up, the tenant doesn't show up, you are going to automatically lose. And if the landlord doesn't show up, the case should be thrown out. If you're in the mediation Zoom session and you don't have a lawyer, you should ask the clerk that you want to have see the lawyer for the day. This is only in housing court. There is no lawyer for the day in district court. But different agencies cover different days of the week, and they provide lawyer for the day. So sort of brief advice. Sometimes they will actually attend the mediation with you. But right now the court is not doing the best job of letting people know about it. And so it would be important for people to actually ask, to say, I want to see the lawyer for the day, and be very insistent on that. And you should get connected. As Miriam said, that if your only reason for the eviction is for non-payment of rent, and you have had some kind of COVID-related hardship, either a decrease in income or an increase in expenses, and you've applied for RAFT or for city funds, the court is required to postpone your hearing. So you need to obviously show the court that you did apply for funds, and the court should postpone. And then if the funds come through, the case should be over. So if the funds don't come through, then the court will just keep on going with the process. And that law was recently extended to April of 2022, so almost a year from now. So people will have that protections. And again, that's something related to COVID.
Unfortunately, I think that the video just froze on Susan. So I know there's questions in the queue, and I also wanted to do some follow-up, but I think we will see if she can come back online, and we'll turn to Maria to talk about resources, and then we'll circle back. This is why we're very glad that we hopefully will be able to get back and doing some of these in person. Thank you.
Okay, well, I am happy to be here. Good afternoon. My name is Maria Mello, and as Maura indicated, I'm the director of the MultiService Center. The MultiService Center assists individuals and families who are homeless or facing housing instability in Cambridge. Our office assists residents with financial assistance for people who have rental.
Now,
Oh,
are you
Sorry.
there,
Susan, sorry, you froze. So we've started with Maria, but we will circle back to you.
Okay, I'm almost done. Sorry. All of a sudden it just started spinning. I don't know what happened. So you have
Okay.
your trial in the eviction process. And again, if you don't show up or you lose at trial, the court's going to issue a piece of paper that's called an execution. And the landlord will give that piece of paper to a constable or a sheriff, and they will be able to physically move you out from your apartment. They will place your stuff in storage and change the locks. And that would happen about 10 days after you either lose at your court date or you don't show up. So you can see that it's probably a several month process depending on the type of eviction. But again, at every step of the way, it's really important that you get legal help. If you are at the very end and you have this notice to move out, most legal services programs are not going to be able to help you because you would have had many chances before that to try to get legal help. So that's in a very quick summary of the different steps in the eviction process. And now I guess we're going to turn it over to Maria.
Well, yes,
Or
we'll
to
go with Maria.
Right. So again, I'm Maria Mello, the director of the MultiService Center, and our center assists individuals and families who are homeless or facing housing instability in Cambridge. Our office assists residents with financial assistance for those who are behind in rent, or other words, rental arrears, for people who have utility arrearages with a shut-off notice. We sometimes provide moving costs such as security deposit and movers. MultiService Center has its own funding, but can assist residents apply for outside funding sources such as Metro's housing, RAFT or ERAP, which stands for the Emergency Rental Assistance Program. I just wanted to mention that these programs often have income guidelines and have other requirements, and that the case managers at the MultiService Center can assist clients through the application process. So you're not on your own through the process of applying for funding. We also have an internal application process for our own funding sources. Our office can meet with clients at any stage of eviction, from 14-day notice to all the way through to 48-hour notice to vacate. We do encourage people to, or encourage clients to reach out when they know they are behind in rent. We do not require a 14-day notice. It's enough to have a late notice or just to know that you're behind in rent. And the goal is really to prevent people from having to enter into the eviction phase of owing rent and going into the eviction phase. Our case managers here at the MultiService Center have had longstanding relationships with management companies, housing authorities, landlords, and will advocate with landlords on behalf of the clients. In cases where we need legal services, we can make referrals to Cambridge Summer Legal Services, to Nova Legal Services, who both are here present with us. We sometimes make referrals to Harvard Legal Aid as well during the school season. If necessary, we can make referrals to mediation services to assist with tenant-landlord conflicts. Along with assisting clients with rent, we also often work on very complex cases, such as apartment buildings being sold and tenants having to vacate, cases where decluttering might need to take place and might cause eviction for that reason, cases where clients need clinical support that is necessary for clients to be successful in their tenancy. We also provide case manager services that assist in aiding clients in applying for financial counseling, the SNAP, which is the old food stamp program, fuel assistance, mass health, unemployment, Social Security benefits, and many other programs. So our case managers are available to help clients, sort of guide them through these application processes. I would suggest Cambridge residents who are currently behind in rent, whether facing eviction or not at this point, or have a shut-off notice from, I believe, Cambridge's Eversource, please reach out to the MultiService Center. Please contact our office, you know, and we will assign you to a case manager. I think our contact information will be provided at the end of this session. So I think that's it for me.
Thank you, Maria. That's a lot, and I think, again, the essential message that we really wanted to bring home during this panel is that there are services, there are resources, and we can walk you through very complicated situations, and we can also help you find the resources to address those situations. We have a number of questions that I think are really good and pertinent to this conversation, of course. And the first one is for either Attorney Hinkle or Attorney Georges. The legal minimum notification period for a notice to quit, is it 5, 10, or even 30 days? I think you talked a little bit about this, Susan, but I don't know if you or Miriam want to expand on the different timeframes for a notice to quit.
Sure. It's going to depend on the type of tenancy and the reason. So most tenants under lease, the lease says that if you break the lease, you can get a 7-day notice to quit. So that's usually the least amount. For non-payment of rent, whether you have a lease or no lease, it's generally 14 days notice. If you are a tenant at will, you will need to do a rental period. So if you pay your rent on the 1st, it would be a calendar month's notice. There are some subsidies that also require just a 30-day notice, or possibly 60 or 90. So it's all going to depend on the reason for the eviction and the type of tenancy that you have, and whether or not there's a subsidy, and whether or not you have a lease. So the typical ones would be the 7, 14, and a calendar month.
And correct me if I'm wrong, I think it's really important for folks to know that, as you said, that only the first step is that notice. And if it's for non-payment and it's cured prior to the end of that notice, folks can avoid the next step in the process.
Right. If it's for non-payment of rent, if you're a tenant at will, you have 10 days to pay up the rent and prevent the eviction. If you're a tenant under lease, you actually have until the answer date, which is 3 business days before your mediation date. So you don't really know quite what it is. But if you do pay up, you also at that point have to pay the court costs, which are like between $250 and $300 now. So it adds quite a lot to the process. So you want to pay up as soon as you can, or get, you know, a commitment letter from the MultiService Center or other agency that they are going to pay.
Thank you. And actually, I was going to kick that right over to Maria, because that commitment letter, I think, is really important information, because a lot of folks think, oh, well, by the time I apply and it comes through, maybe it's too late. But I think that's a really good point. And Maria, maybe you can just talk for a minute about, you know, your experience working with owners and management companies and the commitment letter process.
Yes, so certainly our office is well known to the major management companies in Cambridge, and the Housing Authority knows us well, and we often work with small landlords as well. I think, you know, once an application has been put in with our program and it's approved, we are in touch with the landlord with the client's permission to make a commitment, and there are some forms that commit, you know, that are a contract that is sent to the landlord that the landlord has to fill out and return to us. And it's generally enough to commit, to be accepted as a commitment. And landlords usually accept it, return it to us, and we process for payment. So yeah, I think that it's been sufficient.
Just want to add that you only have the right to cure during one calendar year, which means 12 months. You only have it during one calendar year.
Can you expand on that a little bit, Miriam? So if someone receives a notice to quit in December, do they have a year, or does it have to be cured in that December?
You have the right to cure during the 12-month period.
From the time you receive it?
Exactly. Then after the 12-month period, if that happened again, then you'll have the right to cure. But you have one calendar year, 12 months.
Right. That's for people without a lease. People
Yes,
with a lease can pay
exactly. Go ahead, Susan.
every single month, but you also have to pay the court costs, so it gets expensive.
Very expensive. Yep.
And both of you mentioned the new state rule that if someone has applied for resources, that the court process has to weigh in on that and wait for that to come through. Can you maybe, Miriam, talk a little bit about that and how that is not what the state eviction moratorium was? Those are two very different things.
Sorry, could you repeat the question?
Sure. So you both mentioned Chapter 257, the new rule that if someone has applied for resources, that the eviction process is somewhat delayed or halted. And I think some people, myself could also at one point, you know, it's confusing. There's been so many, there's the federal moratorium, the state moratorium, the local moratorium. Right now, only the federal one is still in play. But I think there's been some confusion over the state moratorium and this new rule. So I just wonder if you could flesh that out a little bit more.
Yes, for Chapter 257, if you have tried to get some rental assistance for a non-payment eviction case, then you can, when you go to court, you explain that and you provide some proof, they should automatically give you more time until the next court hearing. They should give you more time. That's for Chapter 257.
Which is not what the state moratorium was, which I just want people to be clear that those are two different things.
Yes.
And if we collectively are not able to prevent the eviction and it is the judge or the court does rule in the owner's favor, I wonder if one or both of you can flesh that out a little bit more. And one of the questions is, if one gets evicted and possessions are put into storage, who pays for that storage fees?
Well, I guess I should first say, if you show up at your court date and you lose, you do have the right to appeal. So you have 10 days to appeal to a higher court. But there's a lot of steps to that, and it's different from housing court and district court. But if you don't appeal, then this piece of paper is going to issue by the court, and it's good for 90 days. The possession part is good for 90 days. So you will get a notice from a constable that they're coming, minimum of 48 hours, not including weekends or holidays, and it has to be between 9 and 5. And initially, the landlord will have to pay for the storage. But it's somewhat of a shady business, you know, that these are these large eviction warehouses far away. Stuff doesn't always make it to storage, or it gets damaged. So you want to make sure you get your important papers and your personal items, or, you know, things that are not photographs, things that are not replaceable. And but it is the landlord that initially pays for it. And then the landlord can go after you for the money for the storage. And after so many months of the storage company not being paid, they will be able to sell your stuff.
Thank you. Another question that's been put into the chat is, I think, a question for all three of you in a different sense. So there's the legal sense, and then also I think the case management sense of what your team would do, Maria. So the negative impact of an eviction that does happen, that's on one's record, so to speak. There is a movement for eviction ceiling, which would be great, and maybe one of the attorneys could speak with that. And then also, I think the impact of renting for another place. Maybe Maria, you could speak a little bit about how sometimes you and others can work with people to assist that. So we'll start with the attorneys.
You want me to go? Or So the fact that you have an eviction on your record doesn't necessarily mean you've done anything wrong. If a building is being sold and the landlord is evicting you, you've done nothing wrong. But there still is this eviction. And a couple of years ago, when all the records were, available online to anybody, they just type in your name on the court and everything about your case will pop up. There was, a concern about landlords, misusing it and denying you an apartment because you have an eviction, even though nothing was wrong. So there were many legislative efforts to try to prevent anybody from having access to the computer records or the eviction records in certain cases. And the efforts made it pretty close, and it got to the governor's desk but it then didn't get signed, and now there are new efforts. One thing that did get passed is, as of, I think, January of this year, landlords can no longer name minor children on a complaint. And if they do, then it will be sealed. So I think actually today's Globe, front page of the Globe, has a whole story about 100 evictions being filed against a development in Boston, and about the devastating effects of an eviction record on tenants. So
I'll kind of add to that. I think that, certainly I agree with Susan, not necessarily that you have an eviction notice, an eviction on your credit, that it's always a bad thing. So I think a couple of things: when it is for non-payment, and if you fulfilled the payment requirement and have paid that landlord back, we can work with the credit bureaus to provide proof that it's no longer owed, and try to figure out a way to have it removed from the credit. So our office can do that, or we can refer clients to budget counseling, a budget counselor that can help do that. I think there's also, advocacy on our part when there is a eviction, negative eviction on credit, that we can, talk about different programs that might be that a client can, be part of. Sometimes landlords feel a little better if there's a representative payee when a client has a history of eviction for non-payment. Sometimes, it's talking about, the client being successful in a budgeting course, so there's always advocacy that we can do with the client, on behalf of the client, with the landlord. Sometimes we're successful, sometimes we're not, but we, certainly can try. So those are the things we generally do. And we may ask for more detailed, sometimes there's a denial, but it's not clear as to why. And we may ask the credit, the company to provide more information as to why, and help the client sort of navigate the why, because sometimes it's not clear as to why they were denied a housing opportunity. So those are the things we can assist with.
Great. And Susan, you mentioned, sometimes it's, someone is evicted because a building is being sold. And I'm wondering, Miriam, if you could pick up on that a little bit. You know, if someone's building is being sold and they have a lease, can the landlord raise the rent during that transition? And what happens if they try to kick someone out? And is there a difference if they have a tenant, if they're a tenant at will?
So it's very important to say that the lease is the priority. What is on the lease, it's what will occur. So if the lease, if there is a clause in the lease that says that they can increase it, there are some specific rules for that. However, based on the lease, if it does authorize the landlord to raise it, then yes, it's possible to do so. But the landlord, if it's not, incorporated in the lease, then the landlord cannot raise the rent during that period of time. The landlord cannot raise it during your lease period. So it's very important for you to read what's on the lease and to have more information about that. I believe you asked another question, if the landlord can evict the tenant.
If the building is sold, so if the ownership changes hands.
I understand. So if there is a lease, the information on the lease is very important. That's what will govern the tenancy. There are other ways. If the tenant doesn't have a lease, then that's different. The landlord can file a case against the tenant to evict the tenant. So it's very important to know, do you have a lease? Do you have a written document that you sign at the inception of the tenancy? If you do not have a lease, that's also very important for you to know.
And I wonder if either of you would, oftentimes we see a lot of folks who have a lease initially, and then it kind of turns over to a tenancy at will, and someone may live in a place for many years and feel pretty comfortable and confident, as they should. But I wonder if the advice is to always make sure you have a lease or not.
I think there's pros and cons with a lease. But again, as what Miriam said, it's really important to look at your lease and save your lease. So if you've moved in 10 years ago under a lease, especially if in the Section 8 program, there are clauses in the lease that say it automatically renews year to year. So if you have a lease and it doesn't have anything about automatic renewal, then you're just at a month to month. And the advantage of a month to month is that you can move out whenever you want after giving a month's notice. But the disadvantage is that the landlord, can also give you a notice to move on 30 days notice, or a notice saying, I want more rent, or you have to move. So I think it depends in part on somebody's circumstances and, and whether they want to stay there or try to find something less expensive, or they may be moving, out of state.
Okay. I apologize to participants for the weird lighting in my office that goes off while I'm talking. So if that's any distraction, I apologize. It goes off and on. We have two more questions that are connected. And I think Maria and I can take these. And one is, this is more for what the city is doing. So our Cambridge staff monitoring courts to be aware of eviction cases, and also do Cambridge staff monitor the building sales, and do they reach out to tenants? So Maria, I'll let you answer that.
Oh yeah, so certainly I think our group here has been monitoring the eviction cases in the court, and we are aware, and we do outreach to the tenants in hopes that they will reach out and apply for assistance. So that's a continual process for us. And then when we are aware of sales of apartment buildings, we often reach out to tenants and, as a partnership with Mara and Legal Services, to figure out what next steps are for those households facing the sale of that building. So yes, we do reach out to tenants.
And I think that the other part of one of those questions was how many cases are we aware of? And I think it is fair to say, as we have, as a team between the Office of the Housing Liaison and the MultiService Center and our legal service partners and others have been watching and doing outreach, that there was a great fear that when the state moratorium ended in October of last year, that there would be a tsunami of eviction filings. And to date, we've not seen that. Certainly there are some, but we've not seen an exponential increase. In fact, I would venture to say there's been a little bit of a decrease. And I believe that's for three reasons. One, because of the partnerships that have been longstanding in the city with various programs and services in the MultiService Center with management companies. So a number of management companies will outreach to us and ask us to assist their tenants. The other is that the Cambridge Housing Authority and others put in some tenant preservation plans themselves and projects, and they've been working more closely with their tenants. And the last is that the city right away in March, if folks remember, who started the Mayor's Disaster Relief Program, which served over 1,350 households with financial assistance for rent and other needs. And we continue the Housing Stabilization Program, which is still in effect today. And then, as Maria discussed, there's been long-standing other programs that both the city and the state have afforded. So we think with through partnerships and resources that we've been able to really assist a number of our residents. But with that said, and again, why this afternoon's panel was so important is because it's can be complicated, it can be overwhelming. Despite all the resources that we have, not everyone knows about them. So we really want to reinforce that. Come, ask, send your neighbor, send your family, send your friend to any one of us. Talk to us. Don't just leave if you're behind on rent. Don't just leave if you get a notice to quit. Only a court can evict you. And you really do have rights, and there really are a number of resources. With that, I'm going to ask Crystal to put up the our slide of how to contact us, because I see we're right at 3:59, and I really thank our legal partners, Attorney Hagel and Attorney Georges, and of course Maria, and we also thank Stephanie and Farrell for providing closed caption today. And as always, I thank my partners in this effort of Housing Cambridge, Crystal Rosa, who's been behind the scenes today, Emily Cohen, who, Emily Solomon, who was not able to join us today, but is from Community Development Department, and Maria Mello, and also our newest member, Marie Machuchin, the social worker at Cambridge Central Square Library. So thank you, everyone. Please contact us. Here are the contact information. And if you've joined us today, you will receive an email from Crystal with this information. Thank you, everyone. Have a great afternoon.